Hi, welcome back to Focal Point, AFR Talk. Brian Fisher is my name. The program is Focal Point. You were listening to AFR Talk, Focal Point, ethanol-free radio. No additives, just high-octane radio, no corn. Very low corn quotient here on Focal Point. This is beef-fed whatever, pure. Now, corn-fed beef, that's what you're getting here, is corn-fed beef. It's ethanol-free fuel, and it's corn-fed beef. That's what you're getting right here on Focal Point. That's the hazard when you kind of make up these slogans kind of on the spot. So ignore everything I just said. This is high-octane radio, ethanol-free. I'll stand by that. Now, we're looking to hook up with Mat Staver, the Dean of Liberty Counsel. They have filed a lawsuit against Obamacare, and the Supreme Court gave their lawsuit additional life just today. This is breaking news. So we are going to be hooking up with Mat Staver here momentarily. We were talking, and we'll get back to this after we chat with Matt, about this fiscal cliff that we're coming up against, the debt ceiling. And the reality is, it's my argument that we need to urge our representatives, the Republicans in the House of Representatives, not to raise the debt ceiling, period. Just don't do it. Do not raise the debt ceiling. I mean, everybody says we got to get spending under control. We can't keep going on like this. We're just kicking the can down the alley. And then what do? They kick the can down the alley. And if they raise the debt ceiling, they're just going to do that all over again. It's just going to be raising the debt ceiling, putting the United States deeper in debt, more deficit. And I'm looking at a piece here from U.S. News indicating that right now in 2012, we're going to spend $220 billion in net interest on the debt. Now, the reason this is important is we've got about, when you add up income tax and you add up payroll tax, the United States receives about $2.3 trillion in tax revenue. So $220 billion is less than 10% right now of the tax revenue that the federal government has to work with. Now, here's what's important. You're going to hear the Republicans say, look, we can't let the United States go into default. That's why we've got to raise the debt ceiling. We can't let the United States go into default. The only way, ladies and gentlemen, the United States goes into default technically, officially, legally, economically, is if we don't pay our interest on the debt. You don't do that, you go into default. It's like if you miss mortgage payments, you go in to default. That's the only way we can go into default. And so all it takes is $220 billion, well, all it takes, but what it takes is $220 billion a year to keep the United States from going into default. That still leaves $2.1 trillion left over to run this country. And what I say to the Republicans, if you can't find a way to run a country on $2.1 trillion, go home, resign. Let's send somebody to Washington that's got some idea of how to run a country on $2.1 trillion. So don't let the GOP leaders fool you on this. They're going to tell you, hey, we can't let the United States go into default. Fine, we agree. Let's not go into default. All that takes is $220 billion a year. Still leaves $2.1 trillion left over to do everything else. Well, honored and pleased to welcome to our decision maker line a frequent guest here on Focal Point, Mat Staver, who is the founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Matt, welcome back to Focal Point with Brian Fisher.
Thanks. It's good to be with you, Brian.
Well, Matt, one of the reasons I wanted to bring you on, everybody's been talking about Obamacare. We've been talking about the state exchanges, federal exchanges, and sort of the mindset out there. We've even had politicians saying, look, Republican politicians, this is the law of the land. We just have to kind of accept it. But Liberty University has got a case that now is still alive in the federal court system that could change things. Tell us about that.
That's right. Liberty Counsel filed the very first private lawsuit on the day that Obama signed this bill, Obamacare, into law in 2010. So we've been litigating this now for over 2 years. And our case was the very first day of the 3 days of oral argument that was before the High Court and its decision in June. What we did was we filed a petition for rehearing, Liberty Counsel did on behalf of Liberty University and 2 private individuals that we represent, asking the court to allow our case to move forward and be reheard so that we have our day in court. And that's what the court did today. They ultimately agreed with us. Now this means that our case will go back to the Court of Appeals, where we will then argue the employer mandate, whether it's constitutional, which we believe it's not, and then we'll also argue the free exercise of religion as applied to the employer mandate and the individual mandate.
Now, a couple of questions.
That is regarding the abortion, contraception, and sterilization funding.
I want to cycle back to those. I want to go back just for a second. Now, I understand the reason that your court case, and correct me if I'm wrong, the reason your court case is still alive is that when your case was first heard in this lower circuit court of appeals, they didn't even give you the opportunity to make your second and third arguments because they denied you on the first appeal you were making, and that kind of short-stopped the procedure as far as your lawsuit was concerned.
That's correct. Yeah, what the Federal Court of Appeals in Richmond did in 2011 is they said that the Anti-Injunction Act in a 2-to-1 decision applies. And that's that federal law that says if it's a tax, you can't challenge it until you pay the tax, which would mean that they couldn't hear it until 2014, 2015, or sometime thereafter.
So in other words, that Anti-Injunction Act says you can't file a legal challenge against a tax law until you've actually had to pay the tax. Then you can come back to us and complain about it. And since no tax is going to be collected until 2014, they said go away.
That's exactly right, yeah.
And then the Supreme Court turned around and said what?
Well, the Supreme Court said the Anti-Injunction Act doesn't apply. And, in fact, what we did is we petitioned the United States Supreme Court on that Anti-Injunction Act, and the Supreme Court was making a decision. Do they give a separate argument to Liberty University's case, or do they just incorporate it in the other case out of Florida? And so what they did is they took our argument, our petition, and they made it the very first day of the 3 days of oral argument, and that was dedicated to the Anti-Injunction Act. Now, when the court made its ruling in June, the court ultimately ruled that it doesn't apply, meaning that they ruled in our favor, reversing the Court of Appeals. Now, what they should have done in June is what they did today. They should have ultimately then granted our petition because we prevailed. They should have sent it back to the Court of Appeals, and we would be back in the Court of Appeals now. But what they ultimately did is they just simply denied it, just like they did the others that were there, not realizing that we have significant differences than the other cases that were pending. When we pointed that out to the High Court, they required the Department of Justice to respond to that argument because it's very rare for the court to rehear its previous rulings. But today what the court did is actually do that. It reversed its previous ruling on this issue because, indeed, we are right. And that is we prevailed on the Anti-Injunction Act, but we didn't get our arguments presented in the court because they wouldn't listen to them. Now what the Supreme Court has done is said, go back to the Court of Appeals. You have a right to have those arguments in court heard, which will be those arguments that have not been heard yet by the court, namely the employer mandate. Now our argument is that it's unconstitutional.
Now, my understanding, Matt, and maybe you can explain why, is that the Obama administration didn't object to your request for a rehearing on this, and I don't understand why they wouldn't fight that.
Well, the reason is because from a legal standpoint and a historical standpoint, our arguments were unassailable. When we filed the petition and the United States Supreme Court required them to respond, I was trying to figure out what in the world would they respond to other than to agree with us, because there's just no way around it. It was the right decision. There was no way to wiggle out of that. And, in fact, I think that's what they ultimately concluded. So they ultimately agreed that, yes, that's, in fact, what should happen, that Liberty University's case is right. Liberty Counsel's petition should be granted. And so, therefore, they agreed. And now that means after today's ruling, we have hope at the end of the tunnel, and we're going to be back before the Court of Appeals. And here's where we're going to argue. We're going to argue that the employer mandate is unconstitutional. It exceeds congressional authority.
Now, that's, Matt, the question I got for you here is I think a lot of people, and I was under the assumption that the employer mandate part, that had all been settled by the Supreme Court ruling, but you're saying not so.
Not so, because here's what we have. The specific argument will be the employer mandate, like the individual mandate was argued, is unconstitutional. But if the court says that it's constitutional for some reason, we have the free exercise of religion claim, and that applies to both employer mandate and individual mandate. And so here's how it applies to the employer mandate. Employers like Liberty University will be forced to fund abortion through their health insurance policies. That's contrary to our religious beliefs. That's a line we can't cross. That's not inconvenience in being able to practice your religion. That's either or. Either you follow your religious conviction and not fund abortion and disobey the law, or you obey the law and violate your conviction. It's just a no-win game. So that's with the employer mandate. Now, with individuals, where that mandate's already been upheld, there's also now the argument of the free exercise of religion. Does that individual mandate violate the free exercise of religion? We believe it does. Why? Because each person will also be assessed a fee, and that fee goes to funding abortion. And so each person, as well as individual, will become complicit with the taking of innocent human life through Obamacare. And that's a line that many religious people obviously cannot cross. And obviously it applies to abortion, but for others it also applies to contraception and sterilization. So this has a broad sweep across various religious convictions and denominations.
Now, that issue of free exercise of religion, conflict over this requirement for the abortifacient mandate and sterilization and morning after pills and all that, that's actually been adjudicated in a couple of federal courts with conflicting rulings. I think Hobby Lobby argued that. They got turned down by a federal judge. Two other corporations, businesses, have been upheld, saying, yeah, this does violate your religious liberty. So it seems that one way or another, this is going to have to be resolved by this religious liberty issue, going to have to be resolved by the Supreme Court.
I agree. It's going to have to be resolved. I think the decision on Hobby Lobby was wrong. I think that free exercise of religion applies to individuals. It applies to for-profit and not-for-profit employers as well. And there could not be a more conflicting clash between your free exercise of religion under the First Amendment and the federal law known as the Religious Freedom Restoration Act than this one. It's a direct collision, unprecedented in history, and that's why I think it needs to be resolved, and I think that's why we have a good shot at winning.
Our guest on our Decision Maker line has been Mat Staver. He is the founder and chairman of Liberty Counsel, dean of the Liberty University School of Law, and the plaintiff in a case that could wind up leading to significant Supreme Court decision, putting a punch in a hole in the Obamacare boat. So, Matt, thank you for all the great work you're doing there at Liberty Counsel, and thanks for taking time to be with us. And we'll monitor the development of this case, and we'll have you back to chat again.
Thank you. My pleasure to be with you.
God bless you, Matt. Thank you.
Bye-bye.
Matt Staver, dean of Liberty University School of Law, and they've got a court case again that could be extremely significant when it comes to Obamacare and whether that goes into effect in all of its ugliness or not. Focal Point AFR Talk, back in 2.